So, Paul, as Vaughn just mentioned, there's that 30-day window, so his executive order doesn't automatically go into effect in certain jurisdictions or certain states, right? Do you think the Supreme Court's going to weigh in within the next 30 days on the merits?
It certainly won't. What is waiting is for the cases about the substantive issue of birthright citizenship to work their way through the system. So first through the district courts and then through the Court of Appeals and finally to the Supreme Court. So that is not likely to happen until next Supreme Court term at the earliest. And so Justice Sotomayor, in her blistering dissent in this case, said that we now have a system where some people have constitutional rights and others don't. We have this patchwork constitution, which Justice Sotomayor says undermines the rule of law in the United States. This isn't only about the crucial issue of birthright citizenship, but because of federal injunctions, now the Trump administration has been prevented from deporting hundreds of thousands of immigrants. It's been prevented from forcing transgendered women prisoners to be housed with male inmates. It's been prevented from withholding funds from schools that practice diversity. Now, all of those protections go out of the window unless somehow in the next 30 days, all of those litigants can get into the 94 district courts in the United States, get lawyers, and try to get injunctions in those individual courts.
Danny, I see you nodding along. I mean, I guess on this one issue specifically, does it sound like Trump's executive order banning birthright citizenship is going to go into effect, at least in certain parts of the country?
Temporarily, yes, with the idea being, as the Solicitor General argued, that all of these cases, as Paul pointed out, will have to percolate. That was the magic word they used at oral argument. They percolate through the system and make their way up to the Supreme Court. But I have to say that in her blistering dissent, Sotomayor has some pretty good points. Among them are the idea that, yes, one of the things the majority ignored was that the administration lost at every single level, at the district court, at the Court of Appeals. And that's significant to Sotomayor. To the majority, it isn't as important. But the reason it's significant is that this is an example where the forecast is that this executive order will probably be unconstitutional. Why? Because we have a case history. Now, true, the Supreme Court will look at the issue with fresh eyes because it's such a pure legal issue of first impression, but the fact that they've lost at every level is a strong argument for a nationwide injunction,
right,
for enjoining the administration itself. You enjoin the administration from doing what it's doing everywhere as opposed to in one of 94 districts. And so folks understand...
Couldn't the Supreme Court have done that in this case? Couldn't they have said on this issue, this nationwide injunction makes sense? We are marking that right now at this high level, and wouldn't that have provided clarity for a lot of people,
sure,
for the country of millions who are going to be impacted?
Yes, if the dissenters had the majority. But yes, here's one way they could have done it. The majority's rationale is that the idea of an injunction is limited by the Judiciary Act. And so you have to go back 200 years to the 1700s and say, hey, were courts in England enjoining people who are not actual parties before the court? And the majority concludes, no, they did not. You have to have the actual parties before the court. So you can't issue a nationwide injunction because someone in Oklahoma isn't before the court. Someone in Oregon isn't before the court. Therefore, the courts don't have the power to enjoin this activity. But even the majority acknowledges that this concept, it's called equity, the idea of injunctions, is a flexible concept. So if it is flexible, arguably it could have gone the other way, and a nationwide injunction could arguably be constitutional. That's just one way this could have gone in the direction of the dissenters. But the reality is the dissenters are the minority, the predictable three-person minority.
Can I jump in for a second? You know, there is a universe in which there still could be a universal injunction in this case, and it's something that the court discusses with respect to the states. What they say is when the states asked for their universal injunctions, they said it wouldn't be enough just to give them relief in their respective states because their residents could migrate between states, that unless there was something that covered the entire landscape of the country, they, the states that were litigating here, could not get completely relief. And I want to read from Justice Barrett's majority decision, because while she doesn't agree with that per se, she doesn't shut down the executive order wholesale, she leaves that question for another day. She says, We declined to take up these arguments in the first instance. The lower court should determine whether a narrower injunction is appropriate, meaning vis-a-vis the individual states. We therefore leave it to them to consider these and any related arguments. But before she gets there, Anna, she is talking about what those arguments are that the states make. She says, as the states see it, their harms, financial injuries, and administrative burdens flowing from citizen-dependent benefits programs, meaning you have to be a citizen to qualify, cannot be remedied without a blanket ban on the enforcement of the executive order. And then she goes and talks about how the administration says that's not right. You could only apply them to those respective states. She says, you know what? We're not deciding that right now. The lower court should consider both sides of this argument when we throw it back to them. Again, in her dissent, Justice Jackson is saying they even concede that there are some circumstances in this particular case where a universal injunction still might be appropriate. They won't give it to them now, but we could come back to a situation where one of the district courts involved in the state litigation says, even with this decision in hand, I still find a universal injunction is entirely appropriate, and then it goes back to the Supreme Court again.
Again, this was a 6-3 decision, so it broke along kind of party lines. I know that's not the technical term that you use with the Supreme Court, but you have the conservative justices and you have the liberal justices. Amy Coney Barrett wrote the majority opinion, and she said this about nationwide injunctions, quote, "The bottom line, the universal injunction was conspicuously non-existent for most of our nation's history. Because the universal injunction lacks a historical pedigree, it falls outside the bounds of a federal court's equitable authority." Paul, what kind of territory are we in when it comes to checks and balances?
We're in brand new territory where the Supreme Court doesn't seem up to exercising its role as a co-equal branch of government. It's letting the Trump administration get away with things it's hard to believe it will let any other administration get away with. You know, the executive branch has always had the power to issue executive orders, but what's new is the level and scope of what the Trump administration is doing. It's making all of these sweeping holdings that federal courts in all of the birthright citizen cases so far have conceded are probably unconstitutional, but at least for the short term or perhaps the long term, depending on when the court decides to rule on the merits, some people in some states have constitutional rights that people in other states don't.
Yeah, I was just looking for what the lower court said here, Danny, because he's absolutely right that the lower courts all have ruled against the Trump administration's executive order on the merits. Given that this court is not ruling on the merits yet and is allowing the birthright citizenship ban to go into effect in some places, practically speaking, even if it is just temporarily, does that give us any clues as to how this court would rule on the merits?
This is a main focus of Sotomayor's dissent, which is we should take into consideration the fact that the administration has lost at every level. Now, the counter to that argument is that in cases like this, especially cases of first impression on constitutional issues that have rarely, if ever, been decided, there's an argument to be made that every single decision is basically an exhibition match. And that's because the Supreme Court eventually, and actually the appellate court, looks at every one of these legal issues with fresh eyes. So they're not really as bound as they might be with issues of fact, which are usually etched in stone at the trial court level. So there is the counter to that argument, which is, well, maybe it doesn't matter as much that the Trump administration has lost at every level because they could always win at the Supreme Court. But Sotomayor makes a compelling point that it should factor in. This is a great example of something that the government is so likely to lose on. And one of the other things I thought she raised that I thought was important was think about this going the other way. What if the next president, a Democrat president, for example, says, I hereby issue an executive order, we're collecting all the guns. We're collecting them all tomorrow. Right. We're going house to house, and we interpret the Constitution. The Second Amendment is saying, well, we're only talking about militia, and that's, I don't know, the National Guard. Therefore, your AR-15 is now going to be collected by our authorities. Imagine the same thing. Someone would immediately go to a district court to challenge that as unconstitutional. And so now, what does this mean? That we now need to wait for, as Attorney General Solicitor General Sauer said, for these cases to percolate up through the system. Well, we can't do that. So what's good for the goose is good for the gander, is what Sotomayor points out in her dissent.
I mean, Danny brings up a great point, Paul. I mean, the next administration could be a Democratic administration. They may have certain issues that they want to push through, certain policies, and instead of going the legislative route, which oftentimes gets super bogged down, those administrations could just issue executive orders now, right? And they could, in effect, go into effect in parts of the country, if not the entire country, as long as their policy is not challenged by lawsuits in every single district court.
Yeah, that's exactly right. So as a formal matter, this opinion will apply to Democratic administrations and presidents as well as Republicans. And President Obama famously brought a bunch of executive orders that the Republicans didn't like. And to the extent that they were unconstitutional, they would now only, at least in the short term, be unconstitutional in one of the 94 districts where the person brought the lawsuit. So what the Supreme Court suggests in this opinion might be a way to resolve the patchwork quilt of rights that this decision creates is through class action lawsuits. Well, guess what? This court has been very busy limiting the right of people to bring class action. You have to be certified. The judge has to approve a number of issues. So it's difficult, especially in this case, the people who are likely plaintiffs, parents who are expecting a baby. Do we really expect them to run to court, get a bunch of other people to agree with them, and that's the only way that they can have the same rights that people in other states will have?